Okay, I think we'll start. Thank you and welcome to the first in the 2004 Law and IP Masterclass. I'm Brad Sherman. I'll be one of a number of people who are presenting this class. The idea of this series is to provide members of the Centre of Excellence for Plant Success and Synthetic Biology with the fundamentals of intellectual property generally, and then some more specific areas of expertise. The program runs over a series of weeks, and we're moving from the very general, which is today, into more specific topics. If you have any questions, we have time at the end to take questions, so please put them into chat and I'll look at them at the end, or we can raise hands, etc. My plan is to talk for about 45 minutes and then to spend the rest of the time talking, answering questions and discussing things. We have a series of different topics that we're looking at going forward, and one of the things we'll do at the end of the series is to get feedback from people who've attended or people who can't attend, to find out whether you want additional classes going forward. This is being recorded, so just please bear that in mind. Okay. I'd like to begin by acknowledging the traditional owners and the land in which we meet and all listeners are. And I'd like to thank the people in the Plant Success and Synthetic Biology and Carol Ballard as well for helping out in organising this. Today's topic, we'll be looking at the intellectual property very generally. I'll begin by asking the simple question, what is intellectual property? Intellectual property is an area of law. It's a general area of law, a generic term for a number of different legal regimes. The main legal regimes, but not the only ones, are patents, plant breeders' rights, trademark, copyright, moral rights, and designs. There are a host of other ones, many of them that was not relevant, semiconductor chip legislation, etc. During the course of today's lecture, I'll be giving the overview of these different rights, and then we'll be going into more detail in subsequent weeks. The key feature of intellectual property is that it protects certain types of creativity and innovation, and both those terms are very loaded, and there has been a lot of energy gone into defining and extending those terms to deal with different types of activities. Another thing to bear in mind is that a single object may be protected by a number of different types of IP. So a mobile phone, there are probably hundreds or more different types of intellectual property in an object. A plant may contain a number of different types of intellectual property. So, for example, at least the early version of Monsanto's glyphosate-resistant cotton, there were a series of patents over the genetic modifications that Monsanto had done that were put into the glyphosate resistance, and also what's the other thing, the cotton weevil, I can't remember what it's called now. The second aspect of it, there was plant breeders' rights protection over the plant into which those genetic cassettes were inserted, and thirdly, there was trademark protection over the plant as a whole. So if you bought a plant or seed from that plant, you would have to potentially deal with all those three different regimes. The third thing to note about intellectual property is protection is national in focus. There are some international treaties which are important. These just set standards, but they don't really apply in any sense. So a patent only applies in the country in which it is granted. Copyright only applies in the nation state in which it exists. So if someone takes out a patent in New Zealand over a new product of synthetic biology, but not in Australia, then the person in New Zealand could do nothing about someone repeating that invention in Australia. International IP treaties set minimum standards, and we'll go through some of those shortly. One of the key features of intellectual property, and one of the reasons why it was initially introduced, is it protects intangibles. Intangibles are things that can't be seen, smelt, touched. They are able to shift from person to person, and they're able to shift between formats and generations. One of the problems with contract is that it's limited to relations between the person who makes the offer and the person who accepts it. In those scenarios, if the person who accepts, the conditions of, say, I've got this new invention, you can develop a prototype of it, please don't give it to anybody else. If that person gives it to somebody else, I can sue the person who's given it away, but I don't have any legal rights ordinarily against the third party who gets access to the material. Intellectual property was designed to deal with situations when things move beyond the reach of a creator or an innovator. In many situations, social, economic, political, personal connections allow you to control the people around you or work out agreements. But if that person gives it to somebody else or to a third party and it goes on, there's nothing can be done. Intellectual property is the legal technique that allows things to be controlled as they circulate. I want to go now with those general points in mind to talk about the different regimes. The first one I want to talk about is patents. A patent is probably the strongest of all the different types of intellectual property rights. It lasts for 20 years. It has all the characteristics that I mentioned before. It's only applicable in the country in which it's granted. And it allows people to protect certain types of things beyond their sort of interpersonal relations. The key international patent treaties that dominate are the TRIPS, the Trade-Related Intellectual Property Rights regime, which developed over a decade or so in the 90s. It sets out minimum standards. One of the notable things about TRIPS is in relation to plant biological material. The parties couldn't reach agreement. So TRIPS basically says countries can take out patent protection, plant breeders' rights protection, or something else. So it means that there's quite different laws in different countries, which makes our task a little harder. The Patent Cooperation Treaty, the PCT, is an international treaty that allows people to apply for a patent in one country and have that patent replicated in other countries. One of the notable things about a patent is that it is a creature of a registration process. You have to go through an arduous and expensive process. A patent can cost, depending on what you've got, 20 to 50, $100,000 in some cases. And you have to go through a process where you use experts, and those experts and engage with public agents at the Intellectual Property Office to grant the patent. Another key patent treaty or patent-related treaty is International Treaty on Plant Genetic Resources. This treaty establishes a multilateral system that deals with a list of special materials set out in the annex to the treaty. 64 different types of plants are covered. And under the treaty, everybody who receives or uses those plants has to do so using the material transfer agreement. And a key feature of the material transfer agreement is you're not able to take out intellectual property protection over the materials as you receive it. We'll talk more about that in due course. Another important treaty that you may be aware of is the Convention on Biological Diversity, which has been revised a number of times, but the most important recent one being Nagoya in 2013-14, I think it was. Key feature of the CBD that are relevant to us today is that it sets up and requires prior informed consent in relation to the collection of genetic resources. It also requires that there be benefit sharing, monetary and non-monetary, and we'll be having events to do, workshops to deal with these in due course, so going forward. So while there are some important differences between countries, patent protection is very similar in most countries around the world. You could probably say that there are three types of protection. What I'm going to do is provide a general overview of the key features of patent protection, just to provide you with insight into the key things. Firstly, patents are governed by national legislation. Secondly, protection requires registration, and it always requires registration. A patent applies to products and also to processes. So it'll apply to objects and organisms and things, but also applies to processes by which those organisms are made or those products are made. So and there's a third type of related product, which is a product made by a particular process. So for example, if you can see this, but a pen, that someone could have a patent over this particular, or over pens, and there was a patent over the different parts of biros over time. Someone could also have a patent over the process by which the pen was made. And that is not as broad as the product patent, but it's quite important. A third and much more limited protection is one where someone gets a product made by a very specific process, and that is very, very limited, but it can be quite valuable. The last thing about a patent is it lasts up to 20 years. Many patents don't last that long because the technology becomes obsolete, or it's not really worth the while of paying the renewal fees. There are a number of different criteria that need to be met in order to get a patent. The first one, and probably the most important, but the first one is that it covers technology very broadly defined, and different countries have different approaches. Australia still uses the terminology from the 17th century, 16th century of new manufacture. The United States, it's based upon the US Constitution. In Europe, there is a definition of subject matter that is not inventions. But they're all, despite this, fairly similar. There is no doubt that it includes mechanical and chemical inventions. In many countries, it includes plant and animal varieties, although some countries specifically exclude them. Breeding methods, it includes molecular markers for breeding, diagnostic test kits. There's a whole range of different subject matter. The number of criteria that must be met for protection. So once you've met the subject matter requirement, you then must show that your invention is novel, non-obvious, and useful. Novelty is the requirement, basically, that you just have to show that your invention has not been made in any form or disclosed in any form anywhere in the world. And it is incredibly broad. In some ways, it's very easy to breach it if people are able to throw enough money at an application. But basically, the upshot of this is that when you are going through the process of inventing something or putting something together, it's really important you do not disclose anything about the invention, because if you do, you may lose the capacity, if you want, to take out a patent in due course. And this includes giving a lecture in public, disclosing the pen example. There's actually a case where someone was working at a pen factory in the 1950s in northern England. They're coming home from work, the car broke down, it was raining. They went into a shop, someone called a car or someone for them, and they said, in return, they said, "You've been such a nice person. Here's this prototype of this pen, which we're going to patent," etc. The patent was taken out. Competitors found out that the pen had been given away, and that was sufficient to strike down the validity of the patent. So the moral of the story is, if you are going to patent something, don't tell anyone about it. And if you do so, you're going to make sure that the information about the invention is only disclosed in confidential circumstances, which we'll come to in a moment. Second thing is that the invention must be non-obvious. And that basically just means it must be inventive. And it's a bit tautological to say the invention must be inventive. But really what it means is to say that at the date at which the invention was made, it wouldn't have been obvious for people who were experts in that particular field to have done whatever was done. It's a little bit confusing, and it's quite difficult to explain beyond the scope of that sort of limited terms, but it is important to understand what it is. The third criteria is that the invention must be useful. Utility or usefulness is something that has posed very few problems, particularly in relation to biological inventions and chemical inventions. The reason being that new innovations are often able to function as laboratory tools, and that will be sufficient to meet the criteria of utility of usefulness. There are a number of exceptions to patent protection. Many countries have a research exemption, which is very important. And this basically allows people to undertake experimental use for non-commercial purposes on the patent. It is, in some countries, quite restricted. It's not as broad as, say, in relation to plants, in relation to plant breeders' rights, but it does allow people working in non-commercial research environments to undertake research that doesn't lead to a commercial outcome. The next type of intellectual property protection I want to talk about are plant breeders' rights. This is, in Australia at least, was introduced in the 1980s. It was the law. The history is a little bit murky, but it originated in Europe in the 30s and 40s. It is an area of intellectual property that provides specific protection for plant breeders. The international framework for plant breeders' rights, it's based upon the Convention for the Protection of New Varieties of Plants, which, using the French acronym, is UPOV. It's also governed by the TRIPS Agreement, the Agreement on Trade-related Aspects of Intellectual Property, I mentioned before. But as I said earlier, Article 27(3)(b) is quite open-ended, so it allows people to take out whatever type of protection they want, as long as they provide some sort of protection for plant breeders' rights. Australia has been a member of UPOV for some 40 or so years now. The subject matter of plant breeders' rights, it provides exclusive rights in relation to propagating material, so there's seed or clonal material that can be reproduced, and in certain circumstances, it's also to the harvested material, to products derived from the harvested material and essentially derived varieties. Harvested material, so propagating material will be the seed. Harvested material will be the fruit from the plant, the orange. Products derived from the harvest was the orange juice or the marmalade. Essentially derived varieties, it was an extension that was introduced because of a fear about biotechnology was able to undermine the capacity of plant breeder rights owners to get the time to recoup the investment they made. One of the most common rationales for intellectual property is that people are given a limited term of protection in the case of patents and PBR for plants in 20 years and for trees 25 years, is that it allows people the time to recoup the investment they've made. One of the fears that arose as genetic engineering was sort of becoming much more widely used around the world was it was thought that competitors would be able to circumvent the provisions and have something that was different but in competition to a PBR protected plant on the market. So the idea of essentially derived varieties was introduced. It's really never been applied. It's just an example, I think, of a situation where a fear of technology has led to a late change in the law. I don't really think at this stage it's really something that we need to worry about too much. There are a number of requirements that must be met for someone to get PBR protection. Firstly, there must be a breeder. So if someone must breed something, it's a very low threshold, really. People who discover something in a field and then propagate it would qualify as a breeder. It's also necessary that the variety that is protected, it must meet certain things. It must be distinct, which basically means it must clearly distinguish from another variety, and that's a taxonomic criteria, which is judged on taxonomic terms. The plant must be uniform, which means that the plant variety must retain its relevant characteristics when it's propagated over successive periods of time. So if the key feature of the plant is that it's drought resistant, then when you propagate it into another generation, it must also retain that characteristic of being drought resistant. Stable, the relevant characteristics must remain unchanged after repeated propagation. The requirements of distinctness, uniformity, and stability, or DUS, sometime ensure and provide the means to ensure that the property rights which exist in the plants can can be recognised by third parties, and they can work around it accordingly. Another important requirement of plant breeders' right protection is novelty. Unlike patent protection, which I think safely say extends from the time at which the patent is you apply for it. So anything before that, any disclosure before the date at which you lodge the application, destroy it. With plant breeders' rights, there's a period after lodgement, but I think the safest thing to say is that in dealing with any type of intellectual protection, you just want to say that if you want to take a PBR protection or patent protection over a plant or synthetic, creation of any type, make sure that it's not available in any form elsewhere in other jurisdictions. The term of protection, as I mentioned, is 25 years for trees and vines and 20 years for other plant varieties. The longer protection for trees and vines is the rationale for that is simply that it takes longer for a tree or in some cases a vine to fruit. And so it takes longer for people to recoup the benefits that they may get from that particular form of protection. There are a number of exceptions, and these exceptions are very important, really. It doesn't apply to private and non-commercial activities. So it's permissible for someone to take a PBR protected variety and use it at home. It's also permissible for you to take a PBR protected variety and to undertake experiments on it. So you can test the drought resistant sorghum to see whether it's in fact drought resistant. It's also important, and this is key, I think a key characteristic that's very important. It's permissible for people to take a PBR protected variety and to use it to breed other varieties. Without that, it would create a very an environment that was very juridical, so very legal, and so people have been very careful to ensure that people are able to breed from protected varieties. Once a variety is released, the idea is that the breeding period takes sufficient time that the people who have PBR protection over the first variety would have time to recoup the investment in the initial plant. There is also an exception made in some jurisdictions for farm saved seed. So this is the capacity if you have a crop, for example, that you plant using seed, then you're able to take out protection. A PBR, you can buy a bag of seed, you can plant a crop, you can save the seed, and then you can reuse the seed going forward. In many countries, such as in Australia, PBR owners have effectively nullified the farm save seed exception by the way that they recoup investment. And there are effectively two different ways in which you can take out a PBR owner can get, or patentee for that matter, can get a return on their investment. The first one is to get an upfront royalty fee when they sell something. So it's possible that a PBR owner could say, when you buy this tree from me, I want to get a royalty. A part of the payment for the price of the tree will include a license to you to propagate the tree or to use material from the tree, which would otherwise be a breach of my PBR protection. And that's usually regarded as an upfront royalty. One of the other techniques which is widely used in many some plant-related fields is what's known as an endpoint royalty. And this is a situation where instead of, or maybe in addition to paying an upfront royalty, say on the tree or the seed, the farmer will pay a percentage of the royalty or the gate price that they get for the material. So instead of paying for just on the seed, a farmer who grows PBR protected wheat may be under a contractual obligation to pay a percentage of the amount of wheat that they grow from that PBR protected variety. And that the rate, the endpoint royalty rate, will be determined when the farmer delivers the material to the silo, or the nectarine or plum producer sends it to the packing house. So there are points of time, and that effectively means that farmers are able to save seed, but they still have to pay a royalty for doing so. Another important form of protection of intellectual property, and it differs in some ways from, many ways from patents and PBR, a trademark protection. Trademarks, I'm sure in a class, I'd normally point to someone in the room who's wearing a trademark t-shirt or a hat and say, this is a trademark. Trademarks act as indication of source, in theory. They prevent the confusion of consumers, and they're meant to be used as a quality assurance and control. But trademarks have over time taken on different functions, that they also take on value in their own right. But these are really what the key rationales for protection are. The subject matter of a trademark, you can register, and again, like patents and PBR, it's only available where for registration, you have to go through a registration process. You can register distinctive signs, and that will include names like Apple logo, like the Apple logo, brands. It also includes devices, shapes, smells, and aspects of packaging. So, for example, the sound, I haven't got sound there. It also includes sounds. So the Harley Davidson, the distinctive sound of the Harley Davidson engine has been trademarked. The ping of the McCain's microwave fast food, which is used in all their ads, has also been protected. Smell, people have taken out a number of different types of smell-related marks. Things would include car tires that smell like roses, darts, the flights, the feathers on darts to smell like beers, so you can replicate that at-home pub darts feel, if you like. It also includes shapes, so the shape of the mini motor car, the shape of the London taxi have all been registered. You register your subject matter for goods and services. There are a number of features that you really should bear in mind about trademark. The use or intended use is central to both the trademark registration and infringement. So really, you have to be careful when you register to make sure use and intended use is in some ways determined by the class in which you register it. You get protection for 10 years, but one of the things about a trademark, unlike the case with other forms of intellectual, or most other forms of intellectual property, is that they can be renewed indefinitely. So long as someone's willing to pay a fee and there's people out there who want to buy a product that's related, it can happen. There is, in addition to trademark law, in Australia at least, and other related Commonwealth countries or ex-Commonwealth countries, there are common law regime, it's called passing off. And passing off is sort of like a trademark, but it's a protection which is granted where people have not bothered or don't want to take it, go through the process of registering. Registering, you have to write down what you've got, you have to represent it, and you have to pay a fee, and you go to, in Australia, to Intellectual Property Office. If you don't do that, you can still get protection. If you can show that you have developed reputation in relation to the mark that you're talking about, that someone else has misrepresented it, and that there's been damage or the possibility of damage. So, for example, if I set up a fruit stall on the side of a road and call it Brad's Bananas, and I develop a reputation for providing cheap, high-quality bananas, and then someone sets up one and calls Brad Bananas and Oranges up the road, if I can show that people using the area know that my fruit is a particular quality and the other person has misrepresented, and as a consequence, people are not stopping at my store but going to others, I could bring an action for passing off to protect myself. Another form of protection, which is probably, and I say the most important, but is an incredibly important form of intellectual property, although there's some debate about whether it really is intellectual property, but I think it is confidential information. The key features of confidential information is that there's no time limit. It lasts as long as the information remains secret. It's cheap, basically it's virtually free. It's often used in conjunction with other forms of IP protection or other forms of protection, whether it's IP or not. And it's particularly useful, it's really only useful, particularly when you're difficult to reverse engineer an invention. Confidential information is basically a secret. You try and keep something secret. And it's not really the secret in the sense that you're telling one person, telling not to tell someone else. The law intervenes and says in some situations when people pass information from one person to another, that second person is under an obligation, a legal obligation, not to disclose it to somebody else. The requirements for protection, the information must have the necessary quality of confidence. Secondly, the information is imparted in circumstances importing an obligation of confidence and that the defendant has breached that obligation. The first one, the information has a necessary quality of confidence. That really means that it doesn't apply really to things that are trivial or really, really general. So if I said, I told a colleague at work, I have the idea for setting up fruit stalls on the Bruce Highway up to the way to Maroochydore. Don't tell anyone it's a great idea. It would be probably regarded as too general and too vague to attract requirements of confidentiality. It has to be fairly specific in order to attract protection. The second thing is the information must be imparted in circumstances importing an obligation of confidence. I'm sure most of you have walked into a laboratory or an environment and had to sign an agreement saying, what I learn in this environment, I can't disclose. That's a classic example. Contracts of employment will often include obligations of confidence. An obligation of confidence can be imposed just by someone saying, what I'm going to tell you is secret, don't tell anybody. The problem that arises in that situation is just proving that what's happened. It's always much better to have it in writing. There is a second set of circumstances where people can be under an obligation of protection from confidentiality, and that is where it's because of the nature of the relationship between the parties. In legal terms, it's normally regarded as a fiduciary relationship, and effectively what these are situations where there's a power relationship between two people, and if information is disclosed, it will always be between the party with less power to the party with more power. Then the party with more power is under an obligation of confidentiality. So a priest and someone disclosing information, doctor, patient, teacher, student, in some situations. There are situations like those sort of situations where there's a power imbalance and information that's disclosed must not be disclosed to a third party. The third requirement for protection is the defendant must breach that obligation. So this will be where I tell somebody a secret, I tell them, so I give them certain information, I tell them the secret is confidential, and then they breach that by telling a third party what has happened, what is breached. So just a little bit more detail, the information has a necessary quality of confidence. It must not be in the public domain. It doesn't apply to trivial information, ideas that are vague or sort of at the sort of abstract level. Questions of relative secrecy is one that has perplexed the law for a long period of time. And this is basically where you tell a few people at a time. So eventually it could be if you tell enough people, the information moves from being secret to public domain. It's a grey area, but it's something that you need to bear in mind going forward. The circumstances must be imported or an obligation of confidence. Firstly, and this is one that you all should be really conscious of, contract. It'll be expressed in most cases or implied. If you've invented something and you want to give it to a third party to test, or you want to develop a prototype, or you want to share it and you want to keep it secret, then you must say quite clearly that I'm giving you this new type of plant or this new type of, engineered organism, but please don't disclose it to anybody because it's confidential and secret, etc., etc. Many employment contracts will contain conditions of confidence. In some cases, it'll be implied, but in most cases, it's expressed. This is particularly the case where people are employed in any capacity to invent. The level of obligation that an employer owes to the employee differs depending upon where the seniority in an organization. In one case, for example, a cleaner who worked in a vacuum cleaner factory. So the person who went around and cleaned up the vacuum cleaner factory also was a weekend inventor. They invented the vacuum cleaner bag with the cardboard cutout that the hose sticks into, which is incredibly valuable. They were sued by the organization they were working for, and the court said quite emphatically that this person was employed not to invent or design, but they were employed to clean. And as a consequence, their obligation did not extend to include one where they had to disclose inventions to in this case, the vacuum cleaner company itself. So in that case, the cleaner was not under an obligation of confidence. In another case, a senior executive who had no relationship whatsoever to the inventive part of the organization, disclosed information, and it was said that because he was paid so much money, he was so senior organization, he was under an obligation effectively not to disclose anything about the organization that was confidential, and in that case, the company was able to sue him for breach of confidence. The third one, which I've already mentioned, is the nature of the relationship between the parties. And this is basically whereby it's the nature of the power relationship between the parties. It's something that you'd only ever rely upon when when you haven't managed to deal with contract. So if you are getting contracts, you should be careful to read them to make sure whether you are an obligation of confidentiality. And if so, you should be careful what you disclose. Likewise, if you are sharing something, research results to somebody, you don't want that information or the invention to be disclosed to anybody else, you should try and do so under conditions of confidentiality. Thirdly, breach of obligation, disclosure of the information. It really just depends upon the facts of the case. There's no hard or fact rule. It just would be where somebody is told something and they share it to somebody else. Giving them part of the information may be sufficient. Really, it comes down to whether and what the courts regard as valuable. It really will change going forward. The next form of protection that I want to talk about is copyright. Copyright is something that you're probably all familiar with. It is a form of protection. It's one of the oldest forms of intellectual property protection. It applies to artistic, musical works of writing. I'll explain to that. A number of features of it. There is no registration, so copyright is automatic. It does not protect ideas or styles, only protects the expression. We'll come to look at the moment. And the duration, I think in most countries around the world, it's in certain types of copyright, subject matter at least, it's for the life of the author plus 70 years. The subject matter of copyright is incredibly broad. It includes, these are the most of the categories. There's a couple of others that won't really worry us. Literary works, so books, writings, software is now included under literary works. So anything where it's writing-based works, dramatic works, so people, plays, etc. Artistic works, paintings, photographs, sculptures, engravings, artistic works, buildings, plans, musical works, films. It also includes TV broadcasts, sound recordings, and published editions. The most important, really, for our perspective would be literary works, potentially artistic works in figures and designs and things like that, but there may be others as well. The requirements for protection: the copyright work needs to be original, and that effectively just means it must not be copied from someone else. It must be material forms, that must have a shape, at least for even temporarily, and it must be connected to Australia, which really doesn't really matter. But it just means you must be made by a person who's a resident of Australia, or someone else from outside must make Australia. One of the key features, I should say, about copyright is that although other intellectual property rights arise through registration, on creation of a work, so when I write a couple of paragraphs, I automatically get protection, not just in Australia, because it's an original work in material form, and as an Australian, it's connected to Australia. Because of the international regimes, I automatically connected in most countries around the world for my life, plus 70 years after I die. Ownership is very important for the copyright. In the general rule, the author is the first owner, but it's not if the work is produced in the course of employment. And it's, as academics, there's a difference between teaching work and scholarly work. And there are other exceptions for journalists commissioning domestic photographs, etc. But they don't really concern us here. The rights of a copyright owner: you have the right to reproduce the work, to publish, to perform the work in public, to make a communication of the work, an adaptation, and enter into a rental arrangement. So basically, as a copyright owner in a work, you have the capacity to control how that work is used and distributed. The owner is the only person who can exploit the work, so they can only assign, which basically means sell or license the work. So I'm the only person who can give away, arguably, that if I create a work and it's not University of Queensland doesn't make a claim over it, then I can sell that right to somebody else, or I can license it, which means I can say, I give you the capacity to use this work for 10 years, and then it returns to me, or something like that. And a very important type of intellectual property right for researchers and scientists, and it's not well enough known, are moral rights. Moral rights are related to copyright, but they're different in some ways. Moral rights accompany a copyright in a work. They last for the same time period as copyright. And in Australia, there are three important rights. First is the right of attribution. That's the right to be named. If you are a person working on a joint publication and you write, you make a contribution or something that the law regards as a contribution to that publication, and it's published without your name, then potentially your right of attribution, the right to be named as an author of a work, will be breached. The flip side of that is if a group of people are putting together a publication which you don't really like and they put your name on it, then you could object, saying that there's been a false attribution. You could bring an action saying, although my name is attached to that Nature publication, I should not be there because I didn't author, I don't agree with it, etc. The right of integrity: this is the right to object to derogatory treatment or distortion of work. This typically applies to artistic work. So people might buy a Picasso painting and cut it up into 100 pieces and sell part of the painting to people as a part of it, and that was regarded as derogatory treatment. The placement of a religiously inspired artwork in a gallery where people were displaying earrings made out of aborted fetuses was another case where the right of integrity was applied. For our purposes, probably the most important thing would be if you write a work, if you write a paper or something like that, or you help edit something or work on something, and then someone subsequently edits it in such a way that it affects the quality of the work so much that it reflects badly upon you as an academic, you would potentially have a right to an action of integrity. One of the notable things about Australian moral rights, which really limits it in some ways, is that moral rights, if you can consent by contract to allow a third party to infringe. So, for example, if you write an article for a newspaper or sort of encyclopedia, often there'll be clauses in the contract which allow them to edit the document to whatever way they see fit, and there's really nothing you can do. The next, and I think the final type of intellectual property protection I'm talking about, is design protection. Design is something that exists halfway between, I suppose you could say, between patents and copyright. It relates to the visual appearance of objects or products and has both 2- and 3-dimensional form. So both it includes patterns and ornamentation, so carpet. You can get a shirt with a pattern on it would be something that would be protected by 2 dimensions. 3-dimensional, it includes the shape of objects, the feel of a telephone, the feel of a handle, the door handle. Anything in which is applied to a material object gives it a unique appearance. The design must be new, it must be distinctive. You get 10 years protection on registration, that's a maximum. It's examined and registered if you want to sue for infringement. Different jurisdictions have different laws. It's something that really, it doesn't apply to biological materials. So although the design language fits in with the rhetoric of synthetic biology about engineering design, arguably that the design protection would not be relevant going forward. And with that, I will stop sharing. So I'd like to thank you all, and I look forward to seeing you at the next event.